All right, back on record, case People versus Brandon Martin. That's RIF 1506112. Record should reflect Mr. Martin is present with both counsel. The people are present. All members of the jury, alternates are present. Ladies and gentlemen, during the break, the court and the attorneys could go over the additional exhibits that were referred to during the course of the penalty phase. And the following exhibits have been admitted into evidence, will be made available to you. You will also get all of the exhibits from the guilt phase as well. At least initially, you will not get the skulls or the bat, but if you wish to see it again for whatever reason you can. Same process as we used before. With respect to the penalty phase exhibits, the following exhibits have been admitted into evidence. Starting with People's 246 through 261, 263 through 273, and 273A. And once again, all of that will be made available to you during your deliberations. As far as the defense exhibits are concerned that were admitted during penalty phase, you have defense C, G through K, P, W, C, double B, double G, double J through double L, right there, double J, double K, double M, double T, double Q, double U, UU, double X, and then double Y, double Z, then triple A through triple E. Those exhibits will also be made available to you in the jury deliberation room. Now, ladies and gentlemen, I have some instructions that I will be reading to you. You'll get a copy of the instructions if you wish. Additional copies will provide them to you also. Same process that we utilized during the first phase of the trial. You're going to hear two closing arguments this afternoon. First, you'll hear from prosecution, and then you'll hear from the defense. There is no rebuttal argument because there is no burden in this phase of the trial. As you will recall from the instructions and some of the discussions about the penalty phase, it is a weighing process, weighing, mitigating, the aggravating circumstance. So there is no burden from either side. Now, you will hear me read the reasonable doubt instruction once again. It has been modified as it relates to uncharged offenses that were raised during the course of the proceedings. So I will be defining those offenses, and that is the only time that you will be holding the prosecution to the standard of proof beyond a reasonable doubt, and that is for the proof of those uncharged offenses. Other than that limited circumstance, it is a weighing process, and there is no burden on the prosecution. There is no burden on the defense. It is a pure weighing process that we'll be doing. All right, this phase of the trial is to determine the defendant's penalty. The law provides for two possible penalties: death or life imprisonment without the possibility of parole. You must decide which penalty the defendant will receive. At the end of this phase of the trial, I am giving you this set of instructions. Some of these instructions will apply and be the same or similar to what you heard during the guilt phase. However, you must follow only this new set of instructions in this phase of the trial. The first step in this process was the opening statement. Next, the people offered their evidence, which of course included witnesses' testimony and exhibits. After the people's case, the defense also presented evidence. As you've heard all the evidence, the attorneys will then be giving their final arguments, and then I will instruct you on some concluding instructions. After you've heard all of the arguments and all of the instructions, we'll go to the jury room to deliberate. We'll now instruct you on the law that applies in this phase of the case. We'll give you a copy of the instructions to use in the jury room. You must decide whether the defendant will be sentenced to death or life imprisonment without the possibility of parole. It is up to you and you alone to decide what the penalty will be. In reaching your decision, consider all of the evidence from the entire trial, unless I specifically instruct you not to consider something from the earlier phase. Do not allow bias, prejudice, or public opinion to influence your opinion in any way. You must follow the law as I explain it to you, even if you disagree with it. Believe that the attorney's comments on the law conflict with my instructions. You must follow my instructions. Pay careful attention to all of these instructions and consider them together. If I repeat any instruction or idea, you do not conclude that it is more important than any other instruction or idea just because I repeated it. Some words or phrases used during this trial may have legal meanings that are different from their meanings in everyday use. These words and phrases will be specifically defined in these instructions. Please be sure to listen carefully and follow the definitions that I give you. Words and phrases not specifically defined in these instructions are to be applied using their ordinary everyday meanings. Some of these instructions may not apply depending on your findings about the facts of the case. Not assume just because I give a particular instruction that I am suggesting anything about the facts. After you've decided what the facts are, follow the instructions that do apply to the facts as you find them. In reaching your decision, you must consider and weigh the aggravating and mitigating circumstances or factors that were shown by the evidence. An aggravating circumstance or factor is any fact, condition, or event relating to the commission of a crime above and beyond the elements of the crime itself that increases the wrongfulness of the defendant's conduct, the enormity of the offense, or the harmful impact of the crime. An aggravating circumstance may support a decision to impose the death penalty. A mitigating circumstance or factor is any fact, condition, or event that makes the death penalty less appropriate as a punishment, even though it does not legally justify or excuse the crime. A mitigating circumstance is something that reduces the defendant's blameworthiness or otherwise supports a less severe punishment. A mitigating circumstance may support a decision not to impose the death penalty. Under the law, you must consider, weigh, and be guided by specific factors where applicable, some of which that may be aggravating and some of which that may be mitigating. I will read you the entire list of the factors. Some of them may not apply in this case. If you find there is no evidence of a factor, then you should disregard that factor. The factors are as follows. A, the circumstances of the crimes of which the defendant was convicted in this case, and any special circumstances that were found true. B, whether or not the defendant has engaged in violent criminal activity other than the crimes of which the defendant was convicted in this case. Violent criminal activity is criminal activity involving the unlawful use, attempt to use, or direct or implied threat to use force or violence against a person. The other violent criminal activity alleged in this case will be described in these instructions. C, whether or not the defendant has been convicted of any prior felony other than the crimes of which he was convicted in this case. D, whether the defendant was under the influence of extreme mental or emotional disturbance when he committed the crimes of which he was convicted in this case. E, whether the victim participated in the defendant's homicidal conduct or consented to the homicidal act. F, whether the defendant reasonably believed that circumstances morally justified or extenuated his conduct in committing the crimes of which he was convicted in this case. G, whether at the time of the murder the defendant acted under extreme duress or under the substantial domination of another person. H, whether at the time of the offense the defendant's capacity to appreciate the criminality of his conduct or to follow the requirements of the law was impaired as a result of a mental disease, defect, or intoxication. I, the defendant's age at the time of the crimes of which he was convicted in this case. J, whether the defendant was an accomplice to the murder and his participation in the murder was relatively minor. And K, any other circumstance, whether related to these charges or not, that lessens the gravity of the crime, even though the circumstance is not a legal justification or excuse. These circumstances include sympathy or compassion for the defendant or anything you consider to be a mitigating factor, regardless of whether it is one of the factors I have listed above. Do not consider the absence of a mitigating factor as an aggravating factor. You may not consider as an aggravating factor anything other than the factors contained in the list that you conclude are aggravating in this case. You must not take into account any other facts or circumstances as a basis for imposing the death penalty. Even if a fact is both a special circumstance and also a circumstance of the crime, you may consider that fact only once as an aggravating factor in your weighing process. Do not double count that fact simply because it is both a special circumstance and a circumstance of the crime. Although you may consider sympathy or compassion for the defendant, you may not let sympathy for the defendant's family influence your decision. However, you may consider evidence about the impact of the defendant's execution that it would have on his family if that evidence demonstrates some positive quality of the defendant's background or character. You have the sole responsibility to decide which penalty the defendant will receive. You must consider the arguments of counsel and all the other evidence presented during both phases of this trial. In reaching your decision, you must consider, take into account, and be guided by aggravating and mitigating circumstances. Each of you is free to assign whatever moral or sympathetic value you find appropriate to each individual factor and to all of them together. Not simply count the number of aggravating and mitigating factors and decide based on the higher number alone. Consider the relative or combined weight of the factors and evaluate them in terms of their relative convincing force on the question of punishment. Each of you must decide for yourself whether aggravating or mitigating factors exist. You do not all need to agree whether such factors exist. If any juror individually concludes that a factor exists, that juror may give that factor whatever weight he or she believes is appropriate. Determine which penalty is appropriate and justified by considering all of the evidence and the totality of any aggravating and mitigating circumstances. Even without mitigating circumstances, you may decide that the aggravating circumstances are not substantial enough to warrant death. To return a judgment of death, each of you must be persuaded that the aggravating circumstances both outweigh the mitigating circumstances and are also so substantial in comparison to the mitigating circumstances that a sentence of death is appropriate and justified. In making your decision about penalty, you must assume that the penalty you impose, death or life without the possibility of parole, will be carried out. To return a verdict of either death or life without the possibility of parole, all 12 of you must agree to that verdict. You alone must judge the credibility or believability of the witnesses. Deciding whether testimony is true and accurate, use your common sense and experience. You must judge the testimony of each witness by the same standards, setting aside any biases or prejudices you may have. You may believe all, part, or none of any witness's testimony. Consider the testimony of each witness and decide how much of it you believe. Evaluating a witness's testimony, you may consider anything that reasonably tends to prove or disprove the truth or accuracy of that testimony. Among the factors that you may consider are: how well could the witness see, hear, or otherwise perceive the things about which the witness testified? How well was the witness able to remember and describe what happened? What was the witness's behavior while testifying? Did the witness understand the questions and answer them correctly? Was the witness's testimony influenced by a factor such as bias or prejudice, personal relationship with someone involved in the case, or a personal interest in how the case was decided? What was the witness's attitude about the case or about testifying? Did the witness make a statement in the past that is consistent or inconsistent with his or her testimony? How reasonable is the testimony when you consider all of the other evidence in the case? Did other evidence prove or disprove any fact about which the witness testified? Do not automatically reject testimony just because of inconsistencies or conflicts. Consider whether the differences are important or not. People sometimes honestly forget things or make mistakes about what they remember. Also, two people may witness the same event but hear it differently. If you do not believe a witness's testimony, he or she no longer remembers something, that testimony is inconsistent with the witness's earlier statement on that subject. If you decide that a witness deliberately lied about something significant in this case, you should consider not believing anything that witness says. Or, if you think the witness lied about some things but told the truth about others, you may simply accept the part that you think is true and ignore the rest. Neither side is required to call all witnesses who may have information about the case or to produce all physical evidence that might be relevant. Testimony of only one witness can prove any fact. Before you conclude that the testimony of one witness proves a fact, carefully review all of the evidence. During the penalty phase of this trial, you heard evidence that the defendant was involved in a physical altercation with deputies in a courtroom. This evidence was admitted for the limited purpose of establishing or challenging Dr. Abrams' opinion. You may consider that evidence only for that purpose and for no other. You have heard evidence of statements that witnesses made before the trial. Decide if the witness made those statements, may use those statements in two ways. One, to evaluate whether the witness's testimony in court is believable, and two, as evidence that the information in those earlier statements is true. Witnesses were allowed to testify as experts and to give opinions. You must consider the opinions, but you are not required to accept them as true or correct. The meaning and importance of any opinion are for you to decide. Evaluating the believability of an expert witness, follow the instructions about the believability of witnesses generally. In addition, consider the expert's knowledge, skill, experience, training, and education, the reasons the expert gave for any opinion, and the facts or information on which the expert relied in reaching that opinion. You must decide whether information on which the expert relied was true and accurate. You may disregard any opinion that you find unbelievable, unreasonable, or unsupported by the evidence. An expert witness may be asked a hypothetical question. A hypothetical question asks the witness to assume certain facts are true and to give an opinion based on the assumed facts. It's up to you to decide whether an assumed fact has been proved. If you conclude that an assumed fact is not true, consider the effect of the expert's reliance on that fact in evaluating the expert's opinion. If expert witnesses disagreed with one another, you should weigh each opinion against the others. You should examine the reasons given for each opinion and the facts or other matters on which each witness relied. You may also compare the expert's qualifications. Witnesses who were not testifying as an expert gave their opinions during the trial. May, but are not required to, accept those opinions as true or correct. You may give the opinions whatever weight you think appropriate. Consider the extent of the witness's opportunity to perceive the matters on which his or her opinion is based, the reasons the witness gave for any opinion, and the facts or information on which the relied in forming that opinion. You must decide whether information on which the witness relied is true and accurate. You may disregard all or any part of an opinion that you find unbelievable, unreasonable, or unsupported by the evidence. Defendant has an absolute constitutional right not to testify. He or she may rely on the state of the evidence, not consider for any reason at all the fact that the defendant did not testify. Do not discuss that fact in your deliberations or let it influence your decision in any way. The people allege as aggravating circumstances that the defendant committed the following crimes: battery, assault with a deadly weapon other than a firearm, criminal threats. The people must prove beyond a reasonable doubt that the defendant committed each of the alleged crimes. Consider each of the alleged crimes separately. If you have a reasonable doubt whether the defendant committed an alleged crime, you must completely disregard any evidence of that crime. If the people have proved that the defendant committed an alleged crime, you may consider that evidence of the alleged crime as an aggravating circumstance. To decide whether the defendant committed one or more of these crimes, please refer to the separate instructions that I will give you on those crimes. Each of you must decide for yourself whether the people have proved that the defendant committed an alleged crime. You do not all need to agree whether an alleged crime has been proved. If any juror individually concludes that an alleged crime has been proved, that juror may give that evidence whatever weight he or she believes is appropriate. On the other hand, if any juror individually concludes that an alleged crime has not been proved, that juror must disregard that evidence completely. You may not consider any other evidence of alleged criminal activity as an aggravating circumstance. Battery is a violation of Penal Code Section 242. To prove the defendant is guilty of this crime, the people must prove the following elements. 1. Defendant willfully touched Sean Martin and or Michael Martin in a harmful or offensive manner. Someone commits an act willfully when he or she does it willingly or on purpose. It is not required that he or she intend to break the law, hurt someone else, or gain any advantage. The slightest touching can be enough to commit a battery if it is done in a rude or angry way. Making contact with another person, including through his or her clothing, is enough. Touching does not have to cause pain or injury of any kind. The touching can be done indirectly by causing an object to touch the other person. Words alone, no matter how offensive or exasperating, are not an excuse for this crime. Assault is a violation of Penal Code Section 240. To prove the defendant is guilty of this crime, the people must prove the following elements. 1. Defendant did an act that by its nature would directly probably result in the application of force to a person. 2. The defendant did that act willfully. 3. When the defendant acted, he was aware of facts that would lead a reasonable person to realize that his act by its nature directly and probably result in the application of force to someone. And 4. When the defendant acted, he had the present ability to apply force to a person. Someone commits an act willfully when he or she does it willingly or on purpose. It is not required that he or she intend to break the law, hurt someone else, or gain any advantage. Terms application of force and apply force need to touch in a harmful or offensive manner. Slightest touching could be enough if it is done in a rude or angry way. Contact with another person, including through his or her clothing, is enough. Touching does not have to cause pain or injury of any kind. Touching can be done indirectly by causing an object to touch the other person. People are not required to prove that the defendant actually touched someone. People are not required to prove that the defendant actually intended to use force against someone when he acted. No one needs to have actually been injured by the defendant's act, but if someone was injured, you may consider that fact along with all the other evidence in deciding whether the defendant committed an assault, and if so, what kind of assault it was. Assault with a deadly weapon other than a firearm is a violation of Penal Code Section 245, Subdivision A, Subsection 1. To prove the defendant is guilty of this crime, people must prove the following elements. 1. Defendant did an act with a deadly weapon other than a firearm that by its nature would directly and probably result in the application of force to a person, and the force used was likely to produce great bodily injury. 2. The defendant did that act willfully. 3. When the defendant acted, he was aware of facts that would lead a reasonable person to realize that his act by its nature would directly and probably result in the application of force to someone. And 4, when the defendant acted, he had the present ability to apply force with a deadly weapon other than a firearm to a person. Someone commits an act willfully when he or she does it willingly or on purpose. It's not required that he or she intend to break the law, hurt someone else, or gain any advantage. Terms application of force and apply force need to touch in a harmful or offensive manner. Slightest touching can be enough if it is done in a rude or angry way. Contact with another person, including through his or her clothing, is enough. Touching does not have to cause pain or injury of any kind. Touching can be done indirectly by causing an object to touch the other person. People are not required to prove that the defendant actually touched someone. People are not required to prove that the defendant actually intended to use force against someone when he acted. No one needs to have actually been injured by the defendant's act. If someone was injured, you may consider that fact along with all the other evidence, deciding whether the defendant committed an assault, and if so, what kind of assault it was. Great bodily injury means significant or substantial physical injury, an injury that is greater than minor or moderate harm. A deadly weapon other than a firearm is any object, instrument, or weapon that is inherently deadly, or one that is used in such a way that it is capable of causing and likely to cause death or great bodily injury. A criminal threat is a violation of Penal Code Section 422. To prove the defendant is guilty of this crime, the people must prove the following elements. 1. Defendant willfully threatened to unlawfully kill or unlawfully cause great bodily injury to his immediate family. 2. The defendant made the threat orally. 3. The Defendant intended that his statement be understood as a threat. 4. The threat was so clear, immediate, unconditional, and specific that it communicated to his family a serious intention and the immediate prospect that the threat would be carried out. 5. The threat actually caused his family to be in sustained fear for their own safety. And 6. His family's fear was reasonable under the circumstances. Someone commits an act willfully when he or she does it willingly or on purpose. Deciding whether a threat was sufficiently clear, immediate, unconditional, and specific, consider the words themselves as well as the surrounding circumstances. Someone who intends that a statement be understood as a threat does not have to actually intend to carry out the threatened act. Great bodily injury means significant or substantial physical injury. An injury that is greater than minor or moderate harm. Sustained fear means fear for a period of time that is more than momentary, fleeting, or transitory. Immediate ability to carry out the threat is not required. Family means parents, brothers, or anyone related by blood or marriage. Following crimes require general criminal intent: assault with a deadly weapon other than a firearm, and battery. For you to find these uncharged offenses true, that person must not only commit the prohibited act, but must do so with a wrongful intent. A person acts with a wrongful intent, he or she intentionally does a prohibited act. However, it is not required that he or she intend to break the law. The act required is explained in the instruction for that crime. Following crime requires a specific intent or mental state. Criminal threats. For you to find this uncharged offense true, that person must not only intentionally commit the prohibited act, must do so with a specific intent and or mental state. The act and the specific intent and or mental state required are explained in the instruction for that crime. The fact that an uncharged criminal offenses have been alleged against the defendant, not evidence that the offenses are true, must not be biased against the defendant just because it has been alleged that he committed those uncharged crimes. The defendant is presumed to be innocent of the uncharged offenses. This presumption requires that the people prove these uncharged offenses beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you with an abiding conviction that the uncharged offense is true. The evidence need not eliminate all possible doubt, because everything in life is open to some possible or imaginary doubt. In deciding whether the people have proved these uncharged offenses beyond a reasonable doubt, must impartially compare and consider all of the evidence that was received throughout the entire phase of this trial. Unless the evidence proves the defendant guilty beyond a reasonable doubt, he is entitled to a finding that the uncharged offense did not occur. All right, ladies and gentlemen, those are the initial instructions. I'll turn the floor over to the lawyers.
Thank you.